Calling the third set of cases on our list, SJC-11865 and SJC-11866, Robert MacLaurin v. City of Holyoke.
Good morning. May it please the court, Thomas Moore for the appellant property owner, Robert MacLaurin. This matter comes before the court as an appeal of a Western Division Housing Court decision relating to orders of the City of Holyoke Fire Department under Mass General Law, Chapter 148, Section 26I, concerning two residential properties in the City of Holyoke. The property owner...
Are they definitely residential? Is there any possibility that these are this is, because it's a large apartment building, that this is a commercial property?
One of the properties in question had a prior commercial use on the first floor of the building.
No,
so,
I mean, is a multi-apartment, multi-residential unit building a commercial property?
I do not believe so, Your Honor.
Why not? When that person files an income tax return, it's a Schedule C.
I think there are specific guidelines and regulations regarding habitable units within residential buildings that don't apply to commercial structures and commercial buildings. And I believe that the state sanitary code speaks to certain habitability issues related to access to potable water and heating and stove facilities, things you would think of in a normal residential apartment unit that aren't the same type of concern you would get with a commercial building.
Well, they're even more enhanced because you would want a sprinkler system to be operating in a building in the middle of the night when people are asleep so that they can get out when a fire starts. People don't sleep in a commercial building for the most part.
Well, and Your Honor, I think the fire safety concerns are very accurate, and I certainly agree with my sister counsel in the underlying importance of fire safety. And that's certainly something that's not lost on the property owner. And a large building, whether commercial or residential, certainly has a concern about the safety of the occupants. Residential people being there in the middle of the night, I would agree that there is a standard that's heightened. I would also bring the court's attention to the specific dual purpose of the legislation in question. And that speaks to the property owner's point about, in general, the equity of the orders that were issued by the city. In this particular case, the purposes of the legislation were for public safety, of course, and that is a paramount concern when dealing with anything to do with the fire code, of course. But also, the concern was for the lessening, or at least the understanding of a burden that would be placed upon the property owners for disproportionate or exorbitant costs for systems that will be put into older buildings that exist.
We're talking about sprinkler systems now. So
Correct.
We're not talking about just smoke alarms and the like, which of course are required.
Right. In the fire protection system, just for 26I, that is specific to automatic sprinkler systems for residential buildings above 4 units in capacity.
But isn't there, well, 2 points. One, that may be both purposes, but to Justice Spina's point, if you've got a 20 apartment, right, it's 20 unit apartment building?
Yes, that's correct, Your Honor.
That's far from insubstantial in terms of public safety issues. So, I mean, those two purposes may be there, but given the context, one could be perceived as more significant than the other. That's number one. Number two, it is legislation that the city voted to adopt. And I think the court's decision, and I'm not going to remember the case, but it says it can be higher than what the code is. So I guess I don't know why the city isn't able to make that judgment.
I think the city is able to make the judgment. That's not, the property owner certainly doesn't contest the fire chief's ability to issue the order he issued. The problem with the order is that it does not factor in adequately the cost due on the property owner.
Wasn't there dispute about whether the numbers that the property owner had in terms of the amount for the sprinkler system vis-à-vis the renovation costs was actually accurate?
There is a dispute on that factor, Your Honor. That is entirely correct. That kind of presents another issue in the case that's, I guess, somewhat irregular. In this case, there were two orders issued. There were orders issued in 2012 for the properties, I think respectively it was February and March of 2012. And then there was a second order issued, both orders for both properties on December 19th of 2013. That's the result of the housing court action. There was no hearing of any administrative nature performed by the fire department in this case. The property owner certainly recognizes and agrees that that is not a requirement under the statute. But in the Commonwealth, where an administrative body, where the government seeks to issue an order that greatly restrains a fundamental property right, as is the case here, there is an inference that there should be some administrative hearing at least going forward to provide a record so that findings of facts could be issued in support of a written decision.
Correct me if I'm wrong, because I didn't, but doesn't the housing court, it's not that I disagree with the general proposition that somewhere along the line there's got to be a way to test the judgments being made. But isn't the housing court standing order, is it, or something? In other words, isn't there a requirement in this particular instance that everything that the fire chief relied on be made part of the administrative record that then goes to the judge?
That's correct, Your Honor, and that was done by the city. The city provided, when the court case was filed several months after the orders of the city were given to the property owner, the city then produced what it claims was what it relied upon in making the decision. The issue for the property owner is there was no opportunity for the property owner to provide any evidence rebutting mistaken assumptions or to correct the record of facts that were inaccurate. And the order itself contains inaccurate facts that were made as a basis of, reliance upon for the order itself. The original orders back in March discuss demolition work done at the property that was simply never done. And that was a key consideration for the fire chief deciding that this was a major scope of work.
And did he repeat that in his December order?
His December order does not include that. There are several differences in the orders. One specific difference that the property owner finds particularly troubling relates to the idea that the dual legislative purpose was completely ignored in this case, and that speaks to the city's initial discussion of the installation estimates provided for the buildings on Spring Street and Main Street. The March order specifically discusses the estimate and includes what the property owner disputes as inaccurate factual information, but the order issued in December 19th for that property doesn't include any statement about the estimate of the cost for the sprinkler installation. That inconsistency is one of several that the property owner is kind of left at the end of this process to shake, wring his hands and say, what is to be expected of the government in this situation? What can a private property owner anticipate will actually occur when someone is looking to make a 26I determination under Chapter 148? Are they going to factor in the scope of the work, the considerations for fire safety, and then essentially omit any considerations about the actual cost to the owner to put in the system? Is it going to pay, as it did in this case, partial lip service to that particular requirement without doing any actual analysis? And if the court takes a look at the orders, even when the system of installation comes up, the discussion is not about what the cost is or what it's projected to be.
Do you think costs would trump safety in this case?
I think public safety is paramount. I also believe that the legislature was clear that there must be some consideration for exorbitant, disproportionate costs, and I think that's what we have here. In this case, the total cost of the work for the buildings, respectively, is about $186,000 and $207,000, and the respective costs for the alarm systems for each building equates to $124,000 and $133,000.
That's accepting that those numbers are not, there was questions about those numbers.
That's correct. And the questions surrounding the fire sprinkler estimates were specific to plans that were supposed to be submitted. It was the first item on the estimate. And the property owner disputes that this is the case. The fire department claims that it received all the plans it needed for the installation. It doesn't speak to the fact that there might be updated plans filed under this estimate. It doesn't anticipate that that might be the case. It simply says that based on that statement alone, the rest of the report is called into question and is inaccurate. And to go a step further, the city doesn't conduct any analysis on this issue after it makes that statement. What, at the minimum, the city should have done was at least gone into the actual analysis of what the system would have cost, even if that was a market rate assessment that wasn't based on an actual estimate. The burden for the government to act, to come in and take away the rights of the private property owner, their burden is to at least cross that base, at least check that off the list, that they took a look at that issue. They're convinced that the price is not exorbitant in comparison to the cost of the work, but they didn't do that.
Let's talk about that, because if this were new construction, the cost of the sprinklers would be irrelevant, would it not?
If they were new construction, I believe that they would be required. That is correct.
Right, so even if the cost of the sprinkler system were equal to the other renovation costs, it would be too darn bad.
Correct, Your Honor.
So here the issue is, in terms of whether it is the equivalent of new construction, is the focus, is the legislative purpose to say, if it's a new building, we want you to put in sprinklers. If it is the equivalent of a new building, then you also must put in sprinklers. And isn't the cost figure more related to the cost of the sprinkler system as compared to what the cost would be for new construction?
I think the relevant consideration, as is expressed in the building code, to discuss what is considered, I should back up, Your Honor. The term substantial rehabilitation is a complex construction industry term. The city of Holyoke, in its definition of that term, granted the statute does not provide that definition, there's only guidance documents that have been provided. It sought out a standard for commercial property that was basically the major alterations test under Section 26G. It wasn't wrong in seeking guidance from that section. The problem that the city comes up with is that it's faced with a complex contract industry term, and yet it doesn't go to the one source that's the most relevant for construction, which is the building code, which specifically defines substantial renovation. Granted, renovation and rehabilitation are different words, but it specifically defines it in the context of installation of fire protection systems, which is an automatic sprinkler system, in existing structures, whether new construction could be called, or whether the alterations could be called new construction. There's a specific formula related to the cost of work and the cost of the sprinklers, and if the sprinkler costs exceed 15% of the cost of the work being done, that would be considered too egregious to make the requirement.
The city argues that that's out of, that's the 2008 code, and it's not in the 2010 code, or somebody argues that.
I believe the code that applies to this property is the code in effect at the day of the building permit was issued, which in this case would be the 7th edition.
But the point is, looking at the code, that isn't what the current code is, so does that make sense?
Your Honor, it doesn't, but the reason is simply because the Holyoke Fire Department didn't adhere to the guidance that it looked to make its decision. It only selectively chose certain pieces. And one of the pieces that it elected to choose was to go to the major alteration standard. It chose to evaluate the scope of the work. It chose not to evaluate the cost of the sprinkler systems adequately and factor that in towards the total burden and the cost of to the property owner.
And I guess that's, to me, the crux of this case, or might be, which is your view is that the key factor is the cost of the sprinklers versus the cost of renovations. And I'm wondering whether or not the focus on the equivalent of new construction means that the crux of the case should be the cost of the sprinklers for new construction versus what the cost of the sprinklers would be given the scope of the renovations you're doing. That if all you're doing is to replace a wall, then putting a new sprinkler system in would mean you may have to tear down walls and put in a whole lot of work well beyond what you're fixing. But if you're basically going to be transforming that building into a shell, it's as easy to put in the new sprinkler system for the renovations as it would be if it were new construction.
Your Honor, I think that's a reasonable way to look at the section. I think an issue, an equitable issue for the property owner, or any property owner in this case, is what I referred to before, is the lack of any understanding of what's expected and what will be decided by a city or town when looking to invoke the section. Here, again, there was specific guidance that was adhered to, and any guidance that did not support or refuted the decision to install, it was just not discussed.
So what guidance would you recommend we give?
I think the guidance that's existing is on point, albeit there's no exact definition for that term, substantial rehabilitation, to be the equivalent of new construction. I think the city needed to just follow the guidance that was already provided to it by the Automatic Sprinkler Appeals Board and the Building Board of Regulations and Standards and the Building Code. If it had done an all-encompassing review in its order, it would have, I think, satisfied that standard. It just left out that one side of it is not there.
What about Judge Fabricant's standard in, I don't know how to pronounce it, iodice? Iodice?
Yes, that's the one to which I refer, Your Honor. I think that the standard makes sense, that there's a reasonableness to looking towards a similar section within Chapter 148 to see how a test was done for a major alteration versus a substantial rehabilitation. But I also think there's another piece, there's another shoe that needs to be addressed, at least.
So you are or are not with that standard?
I believe that standard is reasonable standard. I believe that
Be satisfied, and as is the fire marshal with that standard.
the fire marshal is satisfied with a part of that standard that supports his claim. He has not included in the order the other parts of the guidance that exist in that case, that exist within the BBRS and the ASAB's guidance documents in this case, which were provided with the briefs. There are pieces he agreed with, and those are the ones he included. The ones that didn't support his conclusion, he did not include.
No, I'm talking about the fire marshal, the state fire marshal.
Yes, Your Honor. I'm
Is that
sorry.
what you're talking about?
I was speaking to the fire chief of the Holyoke, excuse me. I'm sorry, I
I was talking about the
misunderstood.
state fire marshal who submitted an amicus brief
Yes.
and recommends the iodice or iodice standard, and says that it gives local fire chiefs broad discretion in making the determination, taking into account the cost of the renovation project, the nature and scope of the particular work involved, and the relative cost of installation of the automatic sprinklers. And I guess the question is, are you in agreement with the fire marshal that that's the appropriate standard?
I think that is an appropriate standard. In this case, it wasn't followed. And that's,
Well, that's a different question.
correct, Your Honor.
All right, thank you.
Thank you.
Chief Justice Gantz and Associate Justices Kara Cunha, Assistant City Solicitor, on behalf of the appellees, City of Holyoke, Holyoke Fire Department, and Chief John Pond. The Housing Court properly affirmed the order of the Holyoke Fire Chief that sprinkler systems be installed in 2 properties owned by the appellant pursuant to Chapter 148, Section 26I. The orders of the fire chief applied the proper legal standard in finding that the properties were being substantially rehabilitated so as to constitute the equivalent of new construction.
How do we know when something is substantially rehabilitated so as to constitute the equivalent of new construction? How do we know when that is? I mean, there are going to be times, of course, if somebody is doing a very substantial rehab, but it is essentially cosmetic in nature.
Correct.
Is that a time when you say that's the equivalent of new construction?
I think, Your Honor, first to look at the plain language of the statute, substantial rehabilitation rising to the level of new construction. The standard of just substantial rehabilitation, as you just alluded to, is somewhat qualified by the second part, that it has to actually rise to the level of new construction. And I think that is a case where, as was previously alluded to by the court, the building is essentially being completely rehabilitated, where all major systems of the building, such as the plumbing, electrical, gas, are being upgraded, replaced. It's not merely making repairs to the existing fixtures, but new fixtures are being installed. new
Which was
flooring.
the case here, yes?
That is correct. I would submit that based on the administrative record, which in large part included documents produced by the appellant to the city, the evidence is that there, to both buildings, there was work to upgrade or replace the major systems. There were new, completely new electrical services installed with main panels and new electrical services to each apartment. There was heating installed in one of the buildings. Looking simply at the materials, in the Essex Street case, there was nearly 1,000 sheets of sheetrock that were installed in the building, which certainly implies that large areas of walls were opened. In the larger Essex Street building, there was over 5,000 square feet of new flooring and 4,000 square feet of laminate flooring. There were new multiple plumbing permits for new fixtures for the bathrooms and kitchens. So yes, it is the city's position in this case that the work that was done met the standard articulated in Section 26I. And the chief determined this by looking at the factors that were first articulated by the appeals court in the Congregation Beth Shalom case, which is in regards to the major renovation standard of Section 26G. But the Superior Court in Iodice found that it was reasonable to apply those same factors to an analysis under Section 26I.
So are you, do you accept the Iodice, I shouldn't. We need.
I'm not sure about
In any events, IODICE. Do you accept those factors as, those are appropriate governing factors about how we determine what is a substantial renovation?
Yes, Your Honor, and that is the case that the chief relied on and looked to in issuing the orders for these properties. The Iodice case was also clear that the chief is not bound by any particular test or particular numerical ratio, but stated that the chief must clearly identify and determine the factors upon which it's basing its decision and provide an explanation of the test that it is applying. In that case, the court found that the tests articulated were consistent with Beth Shalom, but the court was clear that the chief is not bound by any particular test or numerical ratio.
Well, with respect to procedurally, I understand that you filed in the housing court some kind of record.
Yes, Your Honor.
But is that because the housing court order requires that? I mean, in other words, this isn't governed by 30A. I mean, so there isn't a formal administrative record in that same way.
Sure.
How do you determine what constitutes part of the record? That's one question. My second question is, as part of what the chief was doing, does he formally ask the applicant to submit anything and everything that the applicant wants in terms of showing that this isn't a substantial renovation?
Certainly. To the first question of the administrative record, you were correct. This was filed by the appellant as an action in the nature of certiorari, and so it is governed by the housing court's standing order, which requires the city, in this case, to file the administrative record as its answer. And there is no definition of record. In this case, this was everything that the chief relied upon. It was inspections that were conducted by the fire department. It was documentation that was provided by the appellant to both the fire department and the building department, records of the fire department, records of other city departments such as the assessors and the building department. To your second question as to the process, there was longstanding conversations between the building owner and both the fire department and building department. The inspection that triggered the order to issue the sprinkler systems came about, I believe it's in the brief, but I believe it was when the property owner requested the certificate of occupancy, and an inspection was conducted to determine what other work needed to be done. So certainly there was the opportunity for the building owner to submit any information, and as I said, in large part, the documents showing the particular work that was done were provided by the appellant from his contractors, and in large part, the permits of the city obviously show the particular work that was done as well.
Now, going back to everybody seems to be fond of the Iodice or Iodice factors. One of the factors is the relative cost of installation of the sprinklers. Relative to what? Relative to what it would be if it were new construction, or relative to the overall cost of construction?
I don't recall if Iodice addressed that. I believe it is relative to the cost of the construction. Although I do think Your Honor has raised a good point that the standard obviously has to be the equivalent of new construction. And so I think it is a very reasonable interpretation to compare the cost of the sprinklers in both cases to new construction. I would say that to that point, that I would disagree with the assertion that the chief merely paid it lip service in the order. It was considered, as I would suggest the IDICE court said it has to be as a factor, and there were a number of inaccuracies or inconsistencies challenged in the estimates. Not only that the fire department was already in receipt of plans, but that the estimates identified spaces within the buildings that don't actually exist. And if you look at the two estimates for the buildings, the estimate for the smaller building is actually more than the estimate for the large buildings. So there is seemingly something that is out of whack there.
Was there any analysis done by the fire chief as to what it would have been with new construction? Was that comparison ever considered? Is that part of the record?
No, it's not part of the record.
So we don't know what estimate would be done of this work if it were new construction as opposed to what it is, because Judge Fabricant speaks of the nature of, one of the factors is nature of the work, especially as it facilitates the installation of sprinklers, which suggests that in evaluating this particular work, you're looking at that issue. How hard would it be to install sprinklers given the nature of the rehab work?
And I would submit in this case, the evidence would show that there was extensive plumbing, electrical, namely plumbing work done in obviously extensive sheetrocking that was replaced, therefore walls and ceilings were presumably opened up. The plans for the Essex Street building actually proposed exposed sprinkler heads, which certainly makes the effort to install sprinklers much easier than those which are contained within them.
Can I just get a point of clarification here? Did the owner seek to get the fire chief's input on this matter prior to undertaking construction?
There were plans.
Saying it was done at the time of a certificate of, asking for a certificate of occupancy would suggest that the work was already all done.
There were plans that were submitted to the fire department for sprinkler systems.
Pre-construction?
Yes, in connection with the applications for the building permit. The building permit for the Chestnut and Essex Street property actually lists right on it that automatic sprinklers will be installed.
It was later that the issue came up about not putting them in.
Correct.
Is that right?
The issue came up subsequent because the building permits were issued with the understanding sprinklers were going to be installed because the plans were submitted to the fire department, the work commenced, and then when inspections were requested to see what work was outstanding or somewhere along there, it transpired the sprinklers were not going to be installed.
Were not going to be, or would this be something that wouldn't the sprinklers be installed during the process of the rehab if that's what the plans called for, as opposed to an after installation?
Not being an expert in construction, that would seem reasonable that they would have been installed during the other.
So that there was a disconnect between what was thought was going to be done with this project and in fact what was done, and that may also have played into this?
It may. This was obviously, I don't want to speak for anyone else that was involved, but the building permits were issued based on the fact that plans were submitted.
Are those part of the record, by the way?
The sprinkler plans and the narrative reports are part of the record.
For the original application that show that?
Yes.
This whole process sounds a little haphazard. I mean, do the people who are involved have any sense of what the steps are and what the rules are and what they have to do to comply?
Well, I think, Your Honor, I would go back to the point that the plans were included with the building permit applications, and so I think from the city's perspective, it was expected that the sprinkler systems would be installed. I'm not sure where, somewhere obviously to the point that was made, that didn't happen, and so maybe there was some kind of a breakdown in the inspections.
Trying to figure out, how does somebody know when they have to install sprinklers?
Certainly. So I think the guidance has become clear, both under Section 26G and in a little bit of law that there is on 26I, that when a building permit is applied for, it should be referred by the building official to the fire department, and it's the fire department that makes the determination of whether the sprinkler systems have to be installed. The fire department makes that determination, and if they do in fact have to be installed, the case law through this court's decision in Pinecrest is clear that then these sprinklers are installed in accordance with the technical requirements of the building code. But I would like to note that as far as the argument that the building code should apply, this court did rule on that issue in the Pinecrest case, where you held that the definition of building in the building code did not carry over to Section 26I, and very clearly stated that where there is a conflict between the statute and the regulation, the statute would govern. And I would submit that to hold that the building code definition governs here would be inconsistent with the prior ruling, as well as it was noted by the fire marshal in his amicus brief that the subsequent editions of the building code do not have the definition of substantial rehabilitation or renovation.
Well, could they go ahead and act on the building permit legally if before they got the approval of the fire chief on the issue of the sprinkler system?
Could the building commissioner issue the building permit?
No, could they build? I take it that I understood you to just say that the plans included a sprinkler system, and the building inspector issued a permit.
Correct.
That included the plan for the sprinkler system. Right. But there was an understanding somewhere along the way that the fire chief had to determine, I guess essentially, that it sounded to me as though the fire chief could determine that the sprinkler system was not required. Is that the way you proceed?
Well, I think there's two. I think I was trying to answer the question in an ideal case, the person would come to the building permit, to the building commissioner, it would be referred, and the fire chief would issue the order. In this case, because the plans included the sprinklers, the fire chief didn't issue an order until later when it was determined the sprinklers weren't going to be included. So I recognize that here perhaps things were done a little bit out of order.
Normally, would the building permit issue without the prior approval of the fire chief?
I think it would.
Well, it had the approval. It sounds like it had the approval. It's just that the fire chief didn't say anything because he saw what he needed.
Correct. He didn't issue a formal order because the plans were submitted and had been approved by the fire department.
But my question is, was the fire chief's signature or prior approval required before the building permit could issue?
I don't believe so.
Okay.
That obviously the building commissioner could issue the permit if it met the other requirements of the code.
One last question. We have two rulings or two orders from the fire chief. I take it we should consider them both in conjunction with each other.
Yes, I
Not
would
one
submit
is
that.
superseding.
Yes, Your Honor. As counsel indicated, the second order was as a result of the housing court's remand.
Could I just ask you one question? There was some indication that there was legislation filed about having such a decision reviewed by the automatic sprinkler board or something?
Well, that is just briefly that is an issue with Section 26I. The other parts of Chapter 148 that govern the installation of sprinklers all have appeals to state administrative agencies, namely the Automatic Sprinkler Appeals Board.
But my only question was, the legislation was filed, but it didn't get passed? Is that...
I don't know. I know the fire marshal referenced the fact that they are certainly in support of that legislation. And certainly, I think that is something the legislature needs to correct, to add in that type of appeal.
Thank you.
Thank you.